Good evening, this is Laws 19038. This is Planning and Environment Law. This is John Milburn, the course coordinator. Thank you very much for joining us for week one. We have a few people online. At this stage, I think pretty much everyone is hiding, but occasionally I'll go to gallery view so you can see the people in the class. The session is being recorded. I'm recording the session. I will upload that on to Moodle and uCrew via YouTube. For many of you, I suspect that this is your first foray into legal studies. Maybe some of you have studied at school, maybe you've done other legal classes. So I'll bear that in mind in the context of what we're doing in planning and environment law. Also, I suspect that for many of you, using Zoom and uCrew is a new experience, even though you've studied at this university, Central Queensland, before. These are platforms that I like to use, and I've used them for a number of years, including teaching planning and environment law in different courses over a number of years in different schools. So we've got a lot to cover. I tend to keep the Zoom sessions moving pretty quickly. I aim for 25 minutes. I rarely succeed. Most of the time I go beyond that, but I will try and keep it moving and supplement rather than repeat the information that you can find in the textbook and also on Moodle and in uCrew. Now, a couple of ground rules. The first is that, well, I suppose you want to know who I am before I go into ground rules. So I'm John Milburn. I'm a practicing lawyer. I tend to work in litigation. I teach a number of subjects, includes environmental or planning and environment-based courses. I'll just get you to mute your microphones if you would. Thank you. By all means, you can unmute your microphone. If you want to ask a question, I might get you to Brianne, if you don't mind. Just the bottom left-hand corner is the mute button. Let's see if we can get there. I'm just having trouble. Yeah, that should do it. Right. So you can unmute the microphone if you wish at any stage. And please feel free to take off stop the video recording, and then we'll be able to see you as well, which is always good. Certainly from my perspective, it's nice to be able to see who's in the class. Okay, so let's have a look at the Moodle page first up, just to give you an idea of what I think is important. I won't repeat everything that's there. I'll just highlight a few points. You should be in a position where you can see my Moodle page for the subject. It's probably got more information on the landing page than you're used to. I apologise for that. It won't stay there for long. I will remove a lot of the material, but I'd ask you to please read through that material, have a look at some of those YouTube clips that are there already. It'll give you an idea of the way I like to teach the subject and what I think is important. Most of the discussions that we have during the week will be through uCrew. I appreciate that's probably different to what many of you have had in the past, but uCrew is a great way to share information and to ask questions. Now, very importantly, it's also a place where you can add information. So feel free to initiate some discussions, add some contribution. If you find a great link, provide the link. I really like students to collaborate, and I'll encourage that collaboration as we proceed. So thank you very much for that. If you have a question of me, generally speaking, it should come via uCrew. And if I think it's a question that should go on uCrew, typically what I'll do is invite you to put the question on uCrew, but I'll tell you the answer, tell you what I'm going to put up there. So it won't come as a surprise when I repeat that. Now, those of you online, you've mastered Zoom, so thank you very much for doing that. If you haven't already registered for Zoom, please do so and participate in the sessions. I may move the session time around from time to time, but for the most part, it will be 7:30 each Thursday. And the review activities each week is the exception. That's where I would like you to upload your information through Moodle. Otherwise, your assessment pieces are uploaded through Moodle and everything else goes on uCrew. Now, looking at the assessment pieces, we've got it spaced out, week 7 and week 12, the 2 assessment pieces. In a way, this course is really easy in that you've got no exam, just 2 assessment pieces, and really they're not that difficult, the assessment pieces. At this stage, when you look at them, you might think, oh, this is really technical, it's really difficult, it's legal, but it's not really that hard. So don't get bogged down is the message that I want to give you in terms of the assessment pieces. In terms of the assessment, you'll see the top left-hand corner, that's the link to the assessment. That's the first one due on the 28th of April. And you should upload your assessment via Moodle. Many of you would be familiar with that process already. I think it's always a good idea to put your name and the assessment piece and the name of the subject when you lodge your material. So there's the assessment, and it's to do with the Predajon case in the first part, and then an essay-style question about the legislative basis for the Commonwealth to pass environmental law in the second part. So really, it's pretty simple, so don't get bogged down too much. I'll talk more about the specifics on that assessment later this evening as we progress. Here's the second assessment due at the end of term, 2nd of June. All of my assessment is due on a Thursday evening. So I always do that. I should warn you, it's very difficult to extract an extension from me. I think that's the lawyer in me coming out. If we have a case that starts on Monday, the judge is not interested in whether I had a certain issue or had a bit fluey the week before or anything else. The case has to start, and that's just pretty much it. So I adopt that sort of lawyer approach to the assessment pieces. You can ask for an assessment extension by all means, but you'll probably get an answer of no. You need a really good reason. But there's a bit of a trade-off. If you're late, don't worry, it's not the end of the world. You will simply lose 5% for every day that you're late. Now, there is a catch, and that is that on the Saturday week, which is 9 days after the assessment, I expect all of the answers to be in. And if the answer is not in by the Saturday week, then I will close the assessment and you will get a 0 mark. Now, given that it's 2 lots of 50%, we can't afford a 0 mark. That's effectively going to be a fail. So make sure that you submit something. And bear in mind, of course, that the first 50% is much easier than the second 50%. And the hardest 10% of all is that between 90 and 100. Some comments coming in on the chat facility, which is great. Thank you very much. You can Google the link or just find it in Ostly, says Jade. So thank you very much. And I think that's the best way to go. I don't provide you with links, generally speaking, because part of the assessment is to learn how to navigate your way around the legal websites, and we'll talk about those. Now, I'll just warn you, I'm just going to gallery view. Hi, everyone. We've got just some figures there, some avatars, I guess, almost. All right. If you have a question, please use the chat facility to come in live. Now, I'll go back to the screen share because I want to just run through a few more things on the Moodle page. And I take it that most of you are familiar with Moodle. As I said, there's a lot of material on that landing page, but I will whittle that down. The problems each week, upload that through Moodle, and then, of course, the assessment through Moodle as well. We talked about the extensions. Have a look at my sample document and the way in which I like to present work. I'm not dogmatic in the sense that you must follow my guidelines for presentation. They are simply guidelines. If you disagree, if you think that something other than Calabria or Arial is the right font, then by all means do that. But to get an idea of the way I think, go down to the bottom of the landing page and you'll see a thing called John Milburn's sample document. That will provide you with some guidance and some substantive information as well as a sample layout. In terms of accessing library information, sorry, I'm zooming around here. There's a clip there with former law librarian Kelly Stidiford. I did that a few years ago as part of the Introduction to Law course, I think in 2013. So it's a bit old, but the information is still current and might be useful, particularly if you're not familiar with legal researching. Okay, so are there any questions in relation to the landing page for Moodle or any of that information I've covered so far? And I appreciate that I'm moving pretty quickly. I tend to move fairly fast through these sessions. It's not to discourage questions. I love questions. I love people unmuting the microphone and coming in and making a comment or asking a question. But if you do want to ask anonymously, you can always ask the question and I'll just simply refer to it in this commentary as well. Okay, so there's a few comments there about how to access the web page, etc. Now, in terms of the course approach, you should, of course, consider a textbook, which is Bates. It's a great text. I know it's thick, it's 900 odd pages, but it's quite readable, and of course you won't need everything. I'd really like you to read this as if you want to actually learn it rather than just get through the assessment piece. I know it's tempting, particularly if you've got busy lives, to just do what's necessary for the assessment, and the way the assessment is written, I can't blame you if you do that, but I'd really like you to enjoy the course and understand it. So reading the textbook is important. Now, because I appreciate that we're all time poor and it's a very extensive textbook, you would have seen that I have undertaken a commentary of each chapter. And that's really just my take on what is the important part of the chapter. That is, each one is a YouTube video which I've uploaded to Moodle, and you'll be able to have a look at that week by week or topic by topic. Now, I haven't covered the whole book, but most of the book, and I hope that that's an assistance to you. But bear in mind that just because I mention something from chapter 2, for example, of Bates as being relevant and important, that doesn't necessarily mean that it is the most relevant or important part. You may disagree. You might think that a part that I have not emphasised or not mentioned is in fact very important in the text, and please think critically in that regard. But there are some other textbooks that are really useful, and I'll just run through them quickly. I'll put these on the UCRU site. The Sustainable Planning Act in Queensland is an excellent, relatively short publication by Philippa England, and it really deals with the planning process. So that's more the planning law rather than the environmental law. I was tempted to prescribe both texts, but I was thinking of your wallets. But if you want something to do with the planning side, then England is a really good text. There is another reason I didn't prescribe it, and that is that the text is about to be updated, or it should be updated soon. The Principal Act in Queensland, the Sustainable Planning Act, is about to be repealed, so it will be something that is not necessarily current now as we progress. All right, other textbooks that are good, we have Fisher's text, which is a very useful text. It's along the lines of Bates. It's similarly quite extensive. It's similar to Bates and it's quite theoretical, but it's an excellent text. If you want to look at environmental law from an international perspective, then this is an excellent text. Principles of International Environmental Law. It's quite thick. It's very detailed, but it has some great information in that one. And that's by Sands and Peel, and that's by the Cambridge Press. Now, the next one is Dovers and Hussey. This is a much shorter text, and it's to do with policy. So if you're interested in the policy side of things, that's a very good text. That's by Federation Press. Another one which is right up to date, an excellent publication from Federation Press is Lister and Others. This is the 4th edition. It's brand new. It's comprehensive. It's very well written, and it's quite practical as well, particularly if you have an interest in the New South Wales jurisdiction. I'd commend that book to you. Now, a couple of smaller books. We've got these two. They're both little books. One's a case summary, LexisNexis, and this one here is a nutshell series. by Rachel Baird. I actually like that one. I take that into court quite often, just thumb through that, you know, and highlight relevant parts. So that's a nice, easy one. The only other one I'll mention is really important in the Queensland context. We have the Community Litigants Handbook through the Environmental Defenders Office. This is a great book in that it provides some practical documentation, flow charts and things of that nature. I'll mention those books in the website, the U Crew as well. Are there any questions about the text, the reading? I should say all the notes I rewrote last year late, so they're right up to date. The Sustainable Planning Act, which is the principal act in Queensland, is about to be repealed, unfortunately. So there will be that change, a lot of work for me to change the notes accordingly. But at the moment, the notes that are written on Moodle represent the current law. But look, when it comes to presentation of your assessment work, don't slavishly consider what I've written. Be adventurous. Use flowcharts or diagrams or photographs if you wish. I do encourage you to be creative. The other thing is I encourage you to write in a simple form. Lawyers now try to avoid pompous language. We don't use the archaic language. We tend to use simple, short sentences, and that is definitely my preference when it comes to written material. I don't want it to be casual or conversational in the sense that, for example, abbreviated language is something that I would encourage you not to do. So instead of saying isn't, say is not. You know, don't should be do not. Things of that nature. So it's got to be professional quality, but it's also got to be readable. Now, when it comes to the language in the text and the presentation, I'd encourage you to present your material very professionally. And again, this is the lawyer in me coming out. If you're charging $400 or $500 an hour, people expect something that is professionally presented. So things like spelling, grammar, identifying a case in the correct manner, making sure that your headings are consistent, your font is consistent, your spacing is consistent. All of that, I think, is really important, because when anyone looks at a document, a legal document, they can't help but form an initial impression about the quality of the document based on the way it looks. And if it looks scrappy, it creates the wrong impression, and immediately people are thinking to themselves, why should I pay this person $400 an hour for something that looks very unprofessional? So you should bear that in mind as something that I'm used to when it comes to looking at legal documents. Now, when you're studying your material, you probably think this is quite overwhelming. There's a lot of material, and it is important that you try and keep a cool and clear head and try and remain rational, even if others around you are panicking or overreacting. I'm sure that many of you have studied through Central Queensland already. You may be well advanced in your course, you're probably very used to writing assignments and deadlines, but of course there will be pressure all the way through the course in the sense that deadlines will constantly looming. So I'd encourage you to work backwards. Look at the assessment pieces now, get a feel for the assessment, and start to think about how you might structure the assessment. It is important during this course that you understand how to access good material. And part of the first assessment gives you an opportunity to access a case and comment upon that case. Now, I think from memory, it's the Predajon case. Let's just go and have a look at that first assessment piece and get an idea of what we're looking at. And while I'm doing that, does anyone have any questions? Do you wish to unmute your microphones or ask through the chat facility? Nothing yet? Okay. All right, so the first assessment piece, due on the 28th of April. Slow computer tonight. I think I've got about 10 things happening at once on my computer. Predajon. This is an interesting case. This is a case, oh, we've already got, Jade has already found a link, thank you. This Predajon case is one where a developer sought to develop an environmentally sensitive parcel of land, a beautiful parcel of land. And it's interesting in that you see the way in which planning law and environmental law come together. The judge had to consider issues to do with environmental principles at an international level, such as the precautionary principle, but also consider the planning instruments at the local level and the state level and come up with a decision. In this case of Predajon, both sides were represented by very well-established and well-credentialed and well-regarded legal counsel. I had the privilege of essentially interviewing, if you like, Rod Litzter QC, who was one of the counsel involved in this case. And you will see a YouTube clip in Moodle, which involves a discussion with Rod Litzter about this case. So apart from just reading the case and trying to interpret it from what you read in the judge's decision, if you want some background, why not go and have a look at that YouTube clip with me and Rod Litzter and some other students from the previous iteration, and you'll see some background to the case, and it's very interesting. It's quite detailed, but it's very interesting. The other assessment piece that you've got for the first one involves discussing the legislative basis for the Commonwealth to pass environmental laws, which is really an essay-style question. And then you've got a question in relation to considering a reform directions paper, which is policy. So what I've attempted to do in that first assessment is ask you to provide some commentary about a case, ask you to think about legislation and the interplay between the Commonwealth and the states, and also think about policy issues and think about what governments need to consider in the context of coming up with environmental-based laws. So it's quite a broad spectrum there for that first assessment piece. Now, are there any questions in relation to the first assessment, or is it all clear, no problems? We're all good. Excellent. All right. Well, if you have any questions, please feel free to ask through UCrew. That's where most of our questions should be directed. If you have a question of me, you can send me an email, but if I think it's a question that ought to have been shared with others, I'll invite you to ask that question through UCrew. At the same time, I'll tell you what my answer will be. But it is always good if we share information in that regard, as I'm seeing is happening on the chat facility as we speak. Right, let's have a look at the second assessment. This is due right at the end, and this is a different style of assessment piece. So we have, in the first part, a question that requires you to consider a draft environmental impact statement for the Project China Stone application. Now, this is really interesting in the sense that it shows the way in which decision makers go about considering a major proposal. It brings in the aspects of the environmental impact statement material. It also ties in the state and Commonwealth authorities, and you'll see reference there to the Coordinator General, and the website is the source of the information. So as part of this process for the second assessment, you need to understand the approval process where there are state interests, as in Queensland, and also federal interests. You'll need to consider and comment upon the bilateral agreement regime, how it operates in Queensland and the state of Queensland. Now, as a bit of a tip, there is a connection here between the two assessment pieces, in that the first assessment that requires you to consider the legislative basis for the Commonwealth to make environmental laws is relevant to this bilateral agreement regime, which is part of the statutory approval process referred to in the second assessment. And then the second part of the second assessment requires you to consider an actual case, which is Perpetual Trustees against Cairns City Council, and write some material in relation to that case. And I'll show you how to access some of these things. But as a start, you should consider going to some of the primary sources. And the primary sources are legislation and case law. And Jade has suggested Austlii. I think go to Austlii, AUSTLII. That's a really good starting point for learning about the primary sources of law, which I refer to as legislation or case law. And you should do that now if you haven't already done so. Okay, so that's the assessment regime. Pretty straightforward, nothing difficult about it. The material that you need to consider is actually pretty straightforward. There's a lot of reading, I appreciate that, but don't get bogged down in it too much. It's not that difficult. All right, are there any questions so far? Okay, I should indicate that with my sessions online, I tend to try to keep them about 25 minutes, maybe 30 minutes. I rarely succeed in that endeavour. They normally go much longer, but I try to keep them moving at a fairly brisk pace. That's not to discourage you from asking questions, far from it, but just to get to let you know that I move fairly quickly. Now, in terms of studying environmental law, bear in mind that it's a new discipline. Environmental law is really only about 40 years old. Now, that's important in the context of the Commonwealth and its power to make environmental laws. Does anyone know why I'm saying 40 years is significant when it comes to the Commonwealth making laws about the environment? Any takers? Bit cryptic, I know. All right. So bear in mind, of course, that the Commonwealth has power to make laws only in relation to that which it is constitutionally enabled. Section 51 of the Constitution enumerates a number of powers, and the Commonwealth has power to make legislation in relation to those things that are listed in Section 51. Now, when the Constitution was drawn, no one really thought about environmental law. It wasn't a legal discipline, and that's where the 40 years comes in. It was really only in the 70s that environmental law became a discipline as such. So it's quite new. We're only really at the start of environmental law. So the Commonwealth has power to make laws only in relation to that which is referred to in the Constitution, and the environment is not there. And yet the Commonwealth has an important part to play in environmental law making. And this is really that first assessment, part B of the first assessment. So how does that happen? Well, as I said, environmental law is pretty new. Started in about the 70s. Murphy-Oars case, which dealt with extraction of sand mining extraction on Fraser Island. That was an important early case in environmental law. The Tasmanian Dam case in the 80s, also very important environmental law case. The thing about those cases is that in both instances, the Commonwealth sought to intervene in circumstances where the states, Queensland and Tasmania, saw the role for themselves as legislating. So there was a conflict between the Commonwealth and the states. The Tasmanian Dam case is a very good example of that. And the states, in that case Tasmania, took the matter, took the Commonwealth to the High Court, essentially saying, you can't legislate in relation to this issue because this is a state issue. You don't have power under the Constitution to make these laws. The High Court determined that, in fact, the Commonwealth did have power to make those laws. And the way they did it is this, in short. The Constitution provides for a number of different things. It doesn't provide for the environment, but the environmental-based legislation will often deal with other issues where the Commonwealth does have power. And that issue might be, for example, the foreign affairs power of the Commonwealth, or it might be the trade and commerce power, or other powers that are enumerated in Section 51. there were a spate of cases, in short, during the 80s. Consistently, the states lost to the Commonwealth, and that then prompted the parties, the Commonwealth and the states, to work more cooperatively together, and the COAG, the Council of Local Governments, etc., created an impetus for a group that would assist in the process of dealing with Commonwealth and state laws. So have a look at the COAG, C-O-A-G material. There's a lot of material in the notes about that. And think about that in the context of the Commonwealth's law-making ability. Now, when it comes to the Commonwealth laws, the most important piece of legislation is the Environment Protection and Biodiversity Conservation Act. That's 1999. I'll simply refer to it as EPBCA. So if you're going tonight, during this week, if you're going to have a look at one piece of Commonwealth legislation, it should be EPBCA. But there are other pieces of legislation that are important. There's the regulations that go with the Act, that's important. The Constitution, Section 51, I've mentioned that. But also have a look at Sections 51, 52, and probably 92 and 109. At a Commonwealth level, the Commonwealth Criminal Code is important, and the Administrative Decisions Judicial Review Act is important as well. So that's the Commonwealth legislation. Queensland, I've mentioned the Sustainable Planning Act. It's about to be changed. The Planning Act will take its place. But for the moment, the Sustainable Planning Act of 2009 is good law. That's the act that you should look at as part of your process of investigating environmental legislation. But in Queensland context, other pieces of legislation important that are important are the Vegetation Management Act, Nature Conservation Act, Environmental Protection Act, and the State Development and Public Works Organisation Act. There are others, but they're the key ones. When you're reading the cases, have a look at where the case was determined. So in Queensland, many cases that relate to planning and environment are, and this will come as a huge surprise, dealt with by the Planning and Environment Court. The Planning and Environment Court is actually a branch, if you like, of the District Court. So the P&E judges are actually District Court judges that sit in the Planning and Environment Court jurisdiction. In terms of the hierarchy in Queensland, we have the Supreme Court. Now, the Supreme Court has two divisions. One is the Court of Appeal, and the other is the Trial Division, but they both comprise the Supreme Court. Below that, we have the District Court, and one of the branches of the District Court is the Planning and Environment Court. Another is the CCQ, the Children's Court of Queensland, but for our context, the Planning and Environment Court. Then we have the Magistrates Court, and then we have the Queensland Civil and Administrative Tribunal, where I'm a member, which sits kind of below but off to the side as well. So the P&E Court is important in the context of planning and environment cases in Queensland. At a federal level, it might be the Federal Court or even the High Court. But in Queensland, when you're looking at planning and environment court matters, go and have a look at the Planning and Environment Court decisions. That's really important. So when it comes to primary sources of law, I'm referring to legislation and case law. That's primary sources of law. As good as it is, the text is a secondary source of law. It is essentially, albeit a very knowledgeable person, it is someone's interpretation of the primary sources of law. I encourage you to be independent thinkers. And in the same way that I perhaps indicate that you don't necessarily have to agree with my take on what's important in this, same thing applies when it comes to legislation and case law. Read the primary sources. This is the bad news. You thought, oh, this will be an easy course. We only have to do 2 assignments. There's a lot of reading here. There's a lot of reading in the material that I wrote last year. So it's all right up to date. But also now, I'm asking you to read the cases and the legislation as well. So don't just rely on the secondary sources. Go and have a look at those primary sources. Now, the Planning and Environment Court is interesting in that it has really 2 branches to it. So this is the P&E Court. it has its role in merits reviews, merits decisions, and also in enforcement and criminal matters, enforcement. But in terms of merits reviews, I'll just digress and tell you about that. When an application is considered by an assessment manager, the assessment manager makes a decision based on the merits of the application. Yes, we can understand that. If the assessment manager makes a decision, the decision may be, I reject the application, in which case the developer might appeal. Or the assessment manager may say, I approve the application without condition, in which case someone who put in a submission, an objector, may say, well, that's not right, I'm appealing. Or the third, which is by far the most common, is I'll approve the application, but on conditions. And here are the conditions, 13 pages of conditions. In which case, either the developer may say, this or that or these conditions are unfair, I want an appeal, or an objector may say, I'm not happy with those conditions, I want to appeal. So either way, it goes to appeal. Now I'm doing this little air inverted commas because it's not really an appeal. It's not an appeal against the decision to the Planning and Environment Court. What it is an application for a merits review. And what that means is that the judge in the Planning and Environment Court doesn't actually look at the way in which the decision maker made the decision, but actually starts the process from scratch and will make what we call the correct and preferable decision. So what that means is that the decision maker in those circumstances becomes the Planning and Environment Court. It's a part of administrative law, and it's where the judge steps into the shoes of the decision maker, as it were, and makes the correct and preferable decision. So in the tribunal where I sit, we'll often do merits reviews for things like blue card applications. So I'm familiar with that process in that context. So bear that in mind when you're looking at a Planning and Environment Court. Ask yourself the question, how is it that the judge is making this decision? As if the judge is an assessment manager. Well, the fact is the judge is the assessment manager for all intents and purposes. And you'll see that in the Preda-John case. The other thing that the Planning and Environment Court does is deal with enforcement. So there might be an enforcement case, and I'll show you some examples of that later. For example, Fraser Coast Regional Council against Byrne Brothers, an environmental court decision, dealt with an enforcement application pursuant to Section 601 of the Sustainable Planning Act. Now, I appreciate that I'm giving you a lot of information. You don't have to take it all in right now. Let it flow over the top a bit, but read widely, ask a lot of questions on UCREW, and bear in mind that it's not just a matter of passing the assessment. I really want you to understand this stuff because it's really interesting and it's very important. Okay, I've been doing a lot of talking and talking pretty quickly. Are there any questions, any comments? Does anyone wish to say anything? We're all still hidden, apart from Natasha. Hi, Natasha. All right. Now we go back to speaker view. Apart from the Planning and Environment Court in the Queensland context, other courts that are important is the Land Court. Now that deals mostly with mining litigation disputes. So coal seam gas type issues, coal mines, etc. So the mining industry, a lot of those disputes end up in the Land Court. The Magistrates Court and District Court has jurisdiction to determine criminal prosecutions of environmental law crimes. We'll talk about that in, I think, week 11. There's also the Building and Dispute Resolution Committee, which deals with certain types of development applications, a lot of administrative issues, probably at a lower level, certainly at a lower level than the Planning and Environment Court, but it might deal with things like pool fencing or pool safety non-conforming notices, plumbing and drainage issues, those sorts of things. So one of the difficulties when you're studying planning and environment law is to understand that we have Commonwealth legislation and state legislation, Commonwealth cases, state cases, different courts, tribunals and committees that deal with different types of disputes. And you've got to bear that in mind when you're reviewing this material, because if you're asked to practice in this area, you're expected, of course, to know where to find the legislation and, very importantly, which court or tribunal should you take the matter. Very embarrassing for credibility if you take a matter to the Planning and Environment Court that should in fact be considered by the Building and Dispute Resolution Committee. I hope you understand the importance of that. So keep that in mind while you're doing your reading, these different levels that we talk about. And also think about alternative dispute resolution and the role that it has to play. Now, I'm getting very close to the end of what I want to talk about tonight, just a gentle introduction to the subject. I think we've covered the assessment piece pretty well. One thing I should encourage you to start reading the primary sources. So if we look ahead to week 2, you'll see an assessment guide, which is very important. But also in week 2, I have nominated, and I should share the screen here, sorry. I've nominated where you might access legislation and case law. So Commonwealth, common law is probably the best place to look. If not, at a state level, Queensland, the Office of Parliamentary Counsel, which is authorised, Austlii, which is unauthorised but still very popular and has some great facilities. I actually use Austlii a lot, is there. Barnet Jail is terrific. If you really want to be up to date with your material, with Barnet Jail you can register, and every day you'll receive an email from the service saying, look, you might be interested in this case that came through yesterday. So daily updates through subscription. It's a free service, so it's absolutely fabulous. Then, of course, court websites are great as well. So have a look at that in week 2. Now, generally speaking, my expectation is that you will keep up with your work and you'll be ahead of your work. So in week 1, we should be reading week 2 material. Week 2, we're reading week 3 material, etc. And also, please put in a response to the problem each week, and you do that through Moodle. Any other discussions, any questions, any commentary, if you want to initiate a comment or a discussion, then we do that through UCrew. Okay, well, you've all been very patient with me, and I'm just about to finish now. Are there any questions before I do stop the recording? Because what I'll do is I'll stop the recording and then we can have a discussion off camera. For those of you that are watching this on a delayed basis, I do hope that you consider joining us live at some stage, and that would always be the aim. Watch out, mostly it'll be 7:30, occasionally it may change the time, but it'll always be a Thursday night. All right, well, I'll stop the recording now. Thanks for joining us.